T visas and deportation defense. So we're going to talk about T visas and deportation defense. My name is Helen Tarokic. I'm an immigration attorney. I want to talk to you about this because I get this question all the time from lawyers and from clients. So being a lawyer sounds like it is just getting paid to have anxiety for someone else. And that is true. We worry about our clients. We worry about our team members. We want to get everything right. But the point is you hire an attorney to help you with your removal defense, with your T visa case, and you want to find the best possible way to make sure that you and your family are safe. So the law can change. That's why we have this up here. Law changed half an hour ago. You want to do your best to have a backup plan. And remember, there is a risk to doing nothing at all, right? Or doing nothing at all is also a decision, right? To do nothing. So it's hard to decide if you're going to do a T visa case or not, but I just want to talk a little bit about where T visas can help out with removal defense, or otherwise known as deportation defense. So as I mentioned, my name is Helen Tarokic. I am the owner and founder of Helen Tarokic Law in Wilmington, North Carolina. We're going to talk about the 2024 T visa regulation, which has been implemented in 2025 and now 2026. So this came out a while ago, but it's still called the new T visa regulation. It provides for a Bonafide determination, which means basically the T visa application is pending in good faith for applications that are pending with the Immigration Service. And that Bonafide determination letter also means that your client, or you, if you are the client, can have deferred action while the T visa case is pending with immigration. So when we file a T visa application, we're not just seeking a T visa status for 4 years. We're not just seeking T visa approval so that the client can move on to permanent residency. We're actually filing for 2 different work permits. The first is the Bonafide determination work permit. That is basically symbolic that you have deferred action, which means lawful presence. It's a document that you can show as well because it comes with a Bonafide determination letter that says any order of removal or exclusion or deportation is stayed or basically stopped while the T visa application is pending with immigration. The work permit that we are filing for when it comes to deferred action as part of the T visa case is a Bonafide determination work permit. The category that we're seeking it under is C40. So on the I-765 work permit application, you'll see different categories that can be listed. And C40 was a brand new category that was created in August of 2024 so that those with a Bonafide determination letter basically saying their T visa case appears to be legit, that those people could have work authorization. So if you do get a letter that is not what you want, a letter that says the case is not bona fide, that does not mean that the T visa case is necessarily going to be denied. Now, as an attorney, if I get a letter like that, I definitely go back and look at the file, right? I want to see, are my signatures in order? Was there something weird about the criminal history? I want to talk to my client and say, was there any other contact with immigration? But a lot of our clients with pending T visa applications have a criminal history. They've used different names in the past. They may have a deportation history. They may currently be in deportation or removal proceedings, right? So the file and the purpose of the T visa application was to request forgiveness for that history so that a victim of trafficking can be approved for T visa status. So when I'm going back and looking at the file and talking to my client, if we have a letter saying the case is not appearing to be bona fide, my goal as the attorney is to say, was there something that we don't know about? Like, is there some kind of surprise that nobody has told me about in the client's record or something like that? But otherwise, if I get a nope, everything is just as it is, then really I think that the Bonafide determination letter will have been issued in error. And we've seen lots of that in the beginning of the regulation, especially as they started to implement it. A lot of Bonafide determination letters were issued. A lot of Bonafide determination issued letters were saying that the case is bona fide, that the person can have this new work permit under the regulation. But there were plenty of letters that came out that were like, this isn't bona fide. And they made no sense to me as an attorney whatsoever as I looked at those either in our office or for others. But what we did find was that you can still win your T visa case, right? So we would wait to see if immigration is going to issue a request for evidence that comes to the law office. Then we prepare and submit a response. Then from there, immigration can still approve the T visa case. So getting a Bonafide determination letter is really nice because, again, it means the person shall not be deported while their T visa case is pending. And of course, if things go great and the T visa is approved, then they'd have status and they wouldn't be deported, right? They're going to stay in the United States. Excuse me. But on the other hand, if you get a letter that says the case is not Bonafide, that's, again, something that's not the end game there. It means that your case is going to remain pending, essentially normally. And now we need immigration to make a full T visa decision. So we've had some cases where we got a no Bonafide letter and ultimately were able to win those T visa cases, which was great. So it's one of those things where the regulation was designed to stop or stay a deportation case, or if somebody's never been in deportation, just basically allow them to be here in lawful presence while the T visa case is pending. The idea being people need some protection as trafficking victims. They need to stabilize while their case is pending with immigration. But if somebody doesn't get one, then that just means immigration is going to have to make their full determination later on. So what happens then if you get one of those Bonafide determination letters that says the case is not Bonafide, right? That they don't see it as being essentially one of the cases that they can easily see as something that's approvable. Well, in a case like that, we can file for a mandamus, which is a delay lawsuit. It's a lawsuit that we typically bundle with other cases that we are suing on, meaning that we're asking the Immigration Service to move forward to a full and final T visa decision, hopefully an approval. So mandamus, like in Spanish, like mandar, to like get somebody to do their job. And the idea is we want immigration doing their job faster, right? So if they're going to say, we're not giving you a Bonafide determination letter, or we're going to give you a determination that the case is in Bonafide, then what we want to do, sorry, I'm going to go back here, is make sure that immigration then hurries up and makes a decision on the T visa case. Again, because we want to be confident that the case that we filed is a good case, right? I want to file winnable cases, ones I expect to win. So getting that answer sooner rather than later is what we really want to get the final decision. I also wanted to just mention that even before a T visa case is filed with USCIS, you can have some protections from removal or deportation. We're going to talk about the ICE memo and deconfliction in a bit because it does get a little complicated. When you win your T visa case, if you're in removal proceedings, basically it is mandatory for the immigration judge to terminate the removal proceedings. So in this slide, if you see all the way down at the bottom, it says non-immigrant status as defined in section blah, blah, and then you see a T there, right? S, T, or U. S for snitch visa, T for T visa, U for U visa. So it's not really called a snitch visa, but in any event, the T visa is one for victims of trafficking. So that's one where if you kind of go back up here, you'll see mandatory termination in removal, deportation, and exclusion proceedings. Immigration judges shall, not maybe will, not might think about it, terminate removal proceedings. So another thing here is if your T visa case is denied, USCIS is not supposed to issue a notice to appear for removal proceedings just because the case was denied. I see it on social media. It's driving me crazy. We've seen some case examples as well. But basically, the regulation that came out on August 28th, 2024 clearly states that USCIS generally will not refer a T visa applicant to deportation proceedings while the application is pending, right? Because the idea is you get protection while it's pending. Or following denial of the application, also generally not referring them for removal proceedings. And then they give some exceptions, right? Absent serious aggravating circumstances, like the existence of an egregious, like super serious criminal history, a threat to national security, like are you a terrorist, or where the person is actually part of an act of trafficking. So if a T visa case is denied, then yes, you may see this notice to appear for removal proceedings, but the law says that's not going to happen unless we have a serious aggravating circumstance. And truth be told, many of our T visa clients have significant criminal histories. But they're not egregious criminal histories. I'm guessing there's going to be some comments about that, and I'm okay with it, but we see a lot of approvals for cases where people have had a past drunk driving conviction. Nobody was hurt. They blew over the legal limit. They went to alcohol abuse classes. They completed their substance abuse counseling. They did everything they were supposed to do to repay their debt to society, and now they're in a much better place. So typically driving under the influence in a situation like that, that's something that doesn't even technically require a waiver or forgiveness for the T visa to be approved. So that wouldn't be like a reason for someone to be put into removal proceedings just because immigration said, I don't see how this is a T visa case, we're going to deny it. That would not be, in my opinion, and based on my professional experience, any kind of aggravating circumstance. A lot of times trafficking victims have a criminal history, and that also made them better targets for traffickers. So a person with immigration status violations or someone who's undocumented already is particularly vulnerable to trafficking. And then on top of that, maybe they have a history of drug or alcohol abuse that contributed to a criminal history. And that may have been something that was connected to the trafficking, right? Sometimes people are in a really bad place. We've certainly had cases where people were made to commit crimes by their traffickers, and so those certainly should be waived as part of the T visa process. Those would not be considered to be egregious. We've had cases where a person had drug convictions, a misdemeanor child abuse conviction, the kind of thing where there was like maybe an accusation that there was like a spanking or a slap that should have happened. So not something that would be felony level typically, but something that might have been like a misdemeanor type of an offense. So I think that this regulation is important because what I'm seeing in social media is if your case is denied, you are going to be put into deportation proceedings. And that is not the case. And that's also not the law. And again, the word generally is really important, right? So on the whole, the vast majority of cases would have to have a serious aggravating circumstance in order for those cases to be, let me try again. So the vast number of people who apply for T visa, if any of them are denied, generally immigration would not refer them for removal proceedings, right? Which means that it really has to be like a super exception in order to put them into removal proceedings. So I hope this helps. This is about the law, and then I'm going to give you an example. We had a situation fairly recently where somebody had been denied for T visa status. An appeal on the T visa denial was pending. I love being able to resolve T visa cases on appeal or with a lawsuit in federal court. When a judge sees that kind of thing, they can recognize it often better than the USCIS adjudicator, to be honest. So if somebody's had a denied T visa case, I'm always interested in seeing why it was denied, see if we can't either refile, appeal, or sue. But in any event, this person was placed into removal proceedings. Immigration did not follow the regulation. This person did not have any aggravating circumstances. They didn't have a crazy criminal history. They certainly weren't a terrorist, and they were not a trafficker themselves. So then what happened next was ICE and the immigration judge went forward with termination of removal proceedings. So it wasn't just on our end. We were like, what? This is crazy. The recent 2026 example we have is that the government recognized this should not have happened. It was a notice to appear that was improvidently issued, something that should not have been issued to this person. And so they were able to move forward with waiting for their T visa appeal to go through, and they got some other stuff pending as well. So I give that as an example where if you're thinking about filing a T visa case, you've got to have your eyes wide open when you're walking into the process, right? So You want to be comfortable with your lawyer. You want to feel good about your T visa strategy. You want to be honest in the application that is filed, but also just be aware that there is this regulation that on the whole generally protects people from being put into removal, even if they get a denial. And that regulation doesn't apply to all these other kinds of immigration cases out there. So there's not a parallel regulation that applies to, say, for example, an asylum application. If that is denied out of USCIS, you'll typically see that referred to removal proceedings to go in front of an immigration judge. So there's different rules for different types of cases. Now, under the Biden administration, if the T visa was denied, I never saw a situation where somebody was placed into removal proceedings. And the Biden administration Democrat policy was that they would not place people into removal just because a T was denied. And even under the Trump administration prior to the current one, if a person was denied for T status, they could still file an appeal. And then basically, regardless of the outcome of that appeal, we did not see people placed into removal proceedings. So politics just keeps changing over time. What's going to happen if a case is denied? So if you're going to file one, you want to be confident that you have a good case, right? And like we started out in the beginning of all this, doing nothing is often very unhelpful too, right? Raids, enforcement, all kinds of things to be worried about. So preparing a T visa case, if you are a victim of human trafficking, may be your best removal defense, and also an opportunity to get lawful presence, protection from removal, eventually actual status, and then a path to permanent residency. So, just in general, USCIS, again, if you do get a denial from them, consider an appeal, consider a lawsuit, consider a motion to reopen or reconsider, all of that with a qualified immigration attorney who likes this type of work. And then if you're in removal proceedings or you have an ICE check-in coming up, generally, what we do on our end is we want to make sure that the court is aware or that ICE is aware that we're suing or appealing on the case so that they are aware that they can't just sit around on this, right? We've got some decisions that need to be made at immigration, and the Department of Homeland Security is the umbrella organization over ICE and USCIS. Now, above all, you want to get a consultation from a qualified immigration attorney. Of course, this is not specific legal advice. And as I started in the beginning, right after I publish this, the law can change, right? But if you'd like to get more information, my name is Helen Tarokic, as I mentioned. I'm a licensed immigration attorney. Our law office is based in Wilmington, North Carolina. And this year in August, I'll be celebrating 20 years as an attorney. I've spent my whole career dedicated to immigration law. I wrote a book about T visas. I've published on other T visa topics. I really do love this work, and I think that victims of trafficking who have survived incredible difficulties deserve a chance to legalize their immigration status. So if you'd like a consultation, our office number is 910-509-7145. And please do subscribe to our YouTube channel. I know my videos aren't perfect. I'm doing my best, but I'm trying to get the information out there. We've got some other videos coming up as well, and I hope they'll be of use. Thank you.